Blava & Co Solicitors, committed to excellence.
Quang Huynh from the Family Department. Have you been arguing a lot recently with a partner? Does your argument ever result when your partner drinks alcohol? Does your partner ever become violent after drinking alcohol? Do you feel unsafe or afraid in your current relationship? Has your partner threatened to harm himself or herself and or the children? If you've answered yes to any of these questions, it is possible that you may be suffering from or have suffered from domestic violence in your relationship. Perhaps you know a family member, a friend or work colleague who is suffering from or who has suffered from domestic violence. Domestic violence is prevalent in our society. It now accounts for 15% of all violent incidents. Domestic violence does not discriminate. It can happen to anyone, regardless of age, race, gender, sexuality, religion, disability, wealth, gender, identity or lifestyle. Whilst research shows that domestic violence is most commonly experienced by women and perpetrated by men, it is estimated that at least 1 in 4 women will experience domestic violence at some time in her life. Men also suffer from domestic violence at the hands of their female partners. Domestic violence also takes place in lesbian, gay, bisexual and transgender relationships. It can also involve other family members, including children. So how is domestic violence defined? Currently, the government defines domestic violence as any incident of threatening behaviour, violence or abuse, whether physical, psychological, sexual, financial or emotional, between adults who are or who have been intimate partners or family members, regarding of gender or sexuality. This definition includes so-called honour-based violence, female genital mutilation or cutting, forced marriage. An adult is defined as a person aged 18 or over. The definition is not a statutory or legal definition. It is used by the government departments to inform policy development and other agencies such as the police, the Crown Prosecution Service and the UK Border Agency to inform the identification of domestic violence cases. In December 2011, the government launched a consultation to seek the views on a number of options regarding the current definition of domestic violence, to include victims under the age of 18. Those consulted were the voluntary sector, local authorities, frontline practitioners, independent domestic violence advisors, multi-agency risk assessment conference and the public. In September 2012, the government published their response to the consultation. They announced that the definition of domestic violence would be widened to include those aged 16 to 17 and to include coercive control. It would also change the title of the definition to domestic violence and abuse. The new definition of domestic violence, which will be implemented by March 2013, is any incident or pattern of incidents of controlling, coercive, threatening behaviour, violence or abuse between those 16 or over who are or who have been intimate partners or family members, regardless of gender or sexuality. The abuse can encompass, but is not limited to, psychological, physical, sexual, financial and emotional. Coercive behaviour is defined as an act or a pattern of acts of assault, threats, humiliation and intimidation or other abuse that is used to harm, punish or frighten their victim. Controlling behaviour is defined as a range of acts designed to make a person subordinate and or dependent by isolating them from sources of support, exploiting their resources and capacities for personal gain, depriving them of the means needed for independence, resistance and escape, and regulating their everyday behaviour. All forms of domestic violence and abuse, whether psychological, financial, emotional and physical, come from the abuser's desire for control and power over intimate partners and other family members. For someone who is experiencing domestic violence and abuse, for example a spouse, civil partner, someone in a relationship or family member, can obtain protection from domestic violence from the criminal justice system or from the family court. The protections available from the family court are a non-molestation order and an occupation order made under the Family Law Act 1996. If granted by the court, a non-molestation order can prohibit the perpetrator or someone on their behalf from using or threatening violence against the person seeking the court's protection and from harassing, pestering or intimidating them. The order can go further and prohibit the perpetrator from communicating with the person seeking the order, for example by text messages or emails. The order therefore tells the perpetrator what he or she cannot do against the person in whose favour the order is made. The non-molestation order can extend to the protection of a relevant child, for example, a child from the relationship. The order is usually made for periods of 6 months or 1 year, depending on the seriousness of the molestation. An application for a non-molestation order can be made on an urgent basis, usually without notice to the other party of the application being made when circumstances require it, for example, where there is risk of harm to the person seeking the order or a relevant child attributable to the conduct of the other party if the order is not made immediately. A breach of a non-molestation order is a criminal offence. This means that a breach is dealt with by the criminal court and not by the family court that made that order. The person found guilty of breaching the order can receive a fine or prison sentence or both. A person that can apply for a non-molestation order against the other party, if, for example, they are or have been married, they are or have been civil partners to each other, they are cohabitants or former cohabitants, they are relatives, i.e. father, mother, son, daughter, brother, etc. They have agreed to marry each other. They have entered into a civil partnership agreement. They are parents of the same child. They have or have had parental responsibility for the same child. A child under the age of 16 can apply for a non-molestation order, but with leave from the court. An occupation order regulates a person's entitlement and occupation of a property, such as a family home or former family home. If granted by the court, an occupation order can, for example, enforce a person's entitlement to remain in occupation of the property against the other party, require the other party to allow a person to enter and remain in the property, regulate the occupation of the property by either or both parties, require the other party to leave the property and, having done so, not to return to it or to go within a specified distance from it. A power of arrest can be attached to specified provisions of the occupation order. This means that a police officer may arrest without a warrant the person whom they have reasonable cause to suspect to be in breach of that order. That person must be brought before the family court that made the order within 24 hours of their arrest. How long the occupation order will last will depend on the relationships of the parties. The order can last for a specified time or until further order of the court. There are various orders available. Whether a person can apply for an occupation order depends not only on their status and circumstances, but also on those of the other party. Greater level of protection is offered to couples who are either married or in civil partnerships and property owners. A child under the age of 16 can apply for an occupation order with leave from the court. At Blaver & Co, we have experienced dedicated and committed legal staff, solicitors and caseworkers to handle all your family matters, including the protection from domestic violence and abuse. Our team understands how emotionally difficult and daunting it is when a relationship breaks down, particularly when arising from domestic violence and abuse. Our team are responsive and sensitive to your circumstances and needs. In relation to domestic violence and abuse, we can advise you of the remedies available and represent you on an application to the court to protect you, your children or loved ones. When a matter requires urgent intervention, we can make an emergency application for you. We can represent you under the legal aid scheme. Where legal aid is not available for whatever reason, we can represent you on a privately funded basis with competitive and reasonable private rates being charged and with regular cost updates provided. We are committed to resolving disputes in a non-confrontational way whenever possible. Our team practice family law adopting the resolution code. In our team, we have members of Resolution, First for Family Law, and the Law Society's Family and Children's Panel, and Family Law Advanced Accreditation Scheme and Resolution Accreditation Scheme. With 7 offices in London, Hertfordshire and Surrey, we can offer an appointment at one of our offices which is convenient for you to travel to meet with a member of our team. To contact us, why not visit us on our website www.legalblavo.co.uk or to telephone us on 020 7025 2020.